But now that if this amendment eventually goes through, lots of people are looking to see, okay, what happens with the electronic voting or full electronic voting? Are you of the opinion that perhaps when they're over and done with, we will go ahead, or is it up to INEC to say, well, no, not for this 2019 elections, perhaps the next elections, then we can go full electronic voting?
I think the question of electronic voting can only be brought into being by the National Assembly, following the decisions of the Supreme Court. That's the reason why the card readers were rejected by the Supreme Court in the last elections, that the use of the card readers wasn't backed by an act of the National Assembly.
No, did they use them to vote or for accreditation purposes?
It was used for accreditation, but the point I'm making is that from that decision of the Supreme Court that you need an act of the National Assembly to even back the use of,
or even at any
accreditation. It means that for you to adopt electronic voting, there must be an act of the National Assembly authorizing electronic voting. In other words, INEC cannot of itself say we will use electronic voting unless an act says you may so do. Because that's the reason why the card readers were rejected. They said the card readers' emergence in the electoral process was a product of INEC's regulations and guidelines that wasn't traceable to the Electoral Act. So to that extent, it could not be a basis for invalidating an election.
Okay, so if by this amendment and National Assembly now okays electronic devices and voting, can INEC now determine when they will use the electronic devices, or would that be based on what the National Assembly has said?
Well, I think INEC will determine, because what the amendment did is to recognize introduction of electronic voting without prejudice to manual voting. Without prejudice to manual voting. So INEC, if they are prepared logistically to operate electronic voting in the next election, they can. If they don't, they will go with manual. But what I'm expecting is that the by-election that will come between now and 2019, INEC will be using it to test the electronic voting. They will be using those by-elections under electronic voting, which they cannot do now. So that's why the importance of this amendment the National Assembly has done should not be overlooked. It's very important because it contains 45 clauses of amendment. The one that is in contention is sequence, an issue of local government. So we must be very, very, take it serious that this legislation needs to be passed as quickly as possible.
Let's even look at some of those provisions, just maybe before we wrap up. Some of them say that, yes, much as INEC will now have unfettered powers to conduct elections by electronic voting, but then it also says that presiding officers must now instantly transmit accreditation data and results from polling units to various collation centers. Presiding officer who contravenes this shall be imprisoned for at least 5 years, and they say no option of fine. How do you see this sanitizing the process of elections?
Well, they are trying to emphasize the importance of free and fair election by criminalizing any act of dereliction or negligence or malfeasance by the presiding officer involved. In the accreditation by smart card reader, it's transmitted also. It's already on that as soon as you finish the accreditation, because it's like a handset, the card reader, you send it to your headquarters, they will record the number of those accredited. That's why once the number of accredited voters by the smart card reader conflicts with the result tallied after the voting, it will be nullified.
Do you see us having more cases at the tribunal as a result of this provision, or much less?
Well, I don't think merely listening to that provision one can hazard a guess as to whether it will lead to more or less election petition cases. But what I can say categorically is that it is going to enhance the means of proof of what exactly happened at the polling units. Because once you make it compulsory that, look, you must immediately transmit both the record of the accreditation, and the result of the election. So that means the means of proof is available. And it, I think, automatically eliminates this hijacking of the electoral process.
Yes.
Materials are being hijacked, people are writing results for themselves, and it's an attempt to eliminate that. You know, so at once there is a record of what happened, at once there is the attempt to now eliminate this hijacking of the...
So this makes burden of proof easier, or what?
I think it probably would. Because part of the biggest problem any petitioner has is the means of proving his case. That's the biggest challenge to any petitioner. How do you prove your allegations? INEC itself will generally not cooperate with you, with even making the electoral materials available to you. They're not going to cooperate with you. So that challenge of means of proof is there. And I think this is part of what they want to use to address that. And don't forget that during the last election cycle, that's the 2015 election, most of these electronic data that INEC in fact generated from, they were ultimately not utilized.
But now it will change.
Now that will change.
But what about the courts? Will they be ready for this? Because some say that sometimes the courts are usually slow in admitting some of these cases because I don't know the reasons they gave.
No, even the courts will have less to do.
Yes.
In Anambra, after the election, only 2 election petitions were filed. Unlike Anambra of the past, where they are, for governorship, you have about 20 or 10 election petitions. But this last one, the major political parties did not go to tribunal. It's those that got 45 votes that went to tribunal to test waters, and I think they have disposed of those ones. So once you conduct free and fair election, the judiciary has nothing to do. The tribunal may not even be set up.
Well, it's going to be interesting to see how this eventually pans out. I'll have to thank you for coming on, Chief Emeka Ngige, Senior Advocate of Nigeria, and Mr. Robert Emekwere. Gentlemen, thank you for coming on today.
Thank you very much.